Hereby submit the court the following report. 88 indictments, of which 83 are felonies and 5 are misdemeanors.
Justice, redemption, punishment. These words echo continuously through the cold, concrete walls of Alabama's death row, where John Lewis Evans would spend his final moments contemplating a life marked by violence, desperation, and an irreversible fate. Long before John Lewis Evans became a name synonymous with the first post-moratorium execution in Alabama, he was a child shaped by circumstances few could comprehend. Born on January 4, 1950 in Beaumont, Texas, John Lewis Evans was destined to become a dark footnote in American criminal history. He would hold the grim distinction of being the first inmate executed in Alabama after the United States reinstated the death penalty in 1976, a moment that would become a pivotal example in the ongoing debate about capital punishment. The details of Evans's early life remain shrouded in the limited documentation of working-class families of that era. What we know is fragmentary, snapshots of a young man who would gradually drift from the periphery of society into its darkest margins. The transformation was not sudden, but a slow, inexorable descent that would culminate in a single, devastating moment of violence. In the early 1950s, Beaumont, Texas, was a landscape of industrial promise and economic uncertainty. For young John Louis Evans, childhood was not a time of innocence, but a crucible of survival and hardship. The industrial town, with its oil refineries and working-class neighborhoods, provided little shelter for a child navigating the margins of society. Economic instability breeds desperation, and desperation for some becomes a pathway to crime. For families like Evans's, survival often meant navigating a razor's edge between legitimate opportunity and criminal temptation. Evans's early years were marked by a gradual erosion of societal boundaries. Each minor infraction, each brush with local law enforcement chipped away at the potential for conventional success. His early encounters with the criminal justice system were likely incremental, minor infractions that gradually eroded any sense of conventional moral boundaries. Each interaction with law enforcement, each brush with the legal system would chip away at the potential for rehabilitation, pushing Evans further into a world of increasingly serious criminal behavior. By his late teens, Evans had already begun his descent into criminal behavior. The juvenile justice system became his first real education, not in rehabilitation, but in the intricate mechanics of survival within a system designed to punish rather than reform. His first serious encounters with the criminal justice system came in the late 1960s and early 1970s. Each arrest, each period of incarceration, seemed to harden rather than correct his trajectory. Indiana's prison system became more than just a punishment. It became a training ground for a more sophisticated criminal career. The partnership with Wayne Ritter marked the most dangerous chapter of Evans's criminal life. Together, going on a 2-month killing spree, they became a criminal duo that terrorized 7 states, leaving a trail of destruction that would ultimately lead to their downfall. Their crime spree was unprecedented in its scope and brutality. Over 30 armed robberies, 9 kidnappings, 2 extortion schemes. The numbers read like a criminal's resume, testifying to their ruthlessness and complete disregard for human life. January 5, 1977, a date that would define Evans's entire criminal legacy. The pawnshop in Mobile, Alabama, became the ultimate crime scene. Edward Nassar, the shop owner, became a victim of a crime so brutal it would shock even hardened law enforcement professionals. Nassar's 2 young daughters were also present and witnesses to the demonstration of callousness depicted by those 2. The courtroom became Evans's final stage. Brought to trial on April 26, 1977, he made no attempt to deny his guilt. Instead, he transformed the legal proceedings into a performance of raw, unfiltered menace. Although he gave a detailed confession, prosecutors refused to accept his plea of guilty. Their objective was clear: They wanted Evans sentenced to death, and under Alabama law, this was only possible following a conviction by a jury. Evans was formally tried in State Circuit Court in Mobile, Alabama, for first-degree murder committed during a robbery. During the trial, Evans once again admitted to his crime without hesitation. He showed no sign of remorse, no plea for leniency, and no attempt to portray himself as anything other than what he was, a man who had killed without regret. His words only reinforced the prosecution's case. He declared that, given the same circumstances, he would kill again. And then, in an even more shocking display of defiance, he turned his attention to the jury, delivering a chilling threat. "If you don't sentence me to death, I will escape and murder again. I will hunt each of you down." It was more than just a statement, it was a challenge, a provocation, a declaration of complete moral bankruptcy. At that moment, Evans dared the justice system to do its worst, seemingly embracing his destruction as inevitable. Despite his testimony, the jury was instructed to weigh all the evidence carefully and return a guilty verdict only if they found no reasonable doubt. But the decision did not take long. After less than 15 minutes of deliberation, the jury returned with their verdict. Evans was found guilty of the capital offense as charged, and with that conviction came the automatic imposition of the death penalty.
Everybody give them what they ask for.
The DA says he'll help carry out the jury's wishes.
I anticipate that they'll file motions to plead guilty since their clients want to do so. I'm going to urge the circuit court to set it down and give it priority so that we can dispose of this matter as soon as possible.
So how soon then could they come to trial?
Well, by next Thursday.
Under Alabama law, all capital sentences must undergo review by a higher court before being carried out. Evans's sentence was scrutinized by the Alabama Court of Criminal Appeals, which upheld the decision without hesitation. The Alabama Supreme Court also affirmed the ruling, leaving no room for reversal or clemency. With all legal formalities satisfied, the state set his execution date, April 6, 1979. On April 2nd, Evans's mother, Betty, acting in her capacity as next friend, formally petitioned the U.S. District Court for the Southern District of Alabama for a writ of habeas corpus. The application sought to have Evans's conviction deemed unconstitutional because the jury was not presented with lesser included offenses as an option for conviction. This procedural flaw, she argued, stripped the trial of fundamental fairness and denied Evans a crucial legal safeguard. However, the district court swiftly dismissed her petition. The reasoning? They ruled that Betty Evans did not have the legal standing to act as next friend in this particular case. Undeterred, she pursued an appeal to the United States Court of Appeals for the Fifth Circuit. This move proved to be a turning point, as the appellate court found merit in her claims. Not only did the Fifth Circuit overturn the district court's ruling, but it also went a step further, determining that the initial criminal conviction itself was invalid. This decision was a major legal victory, seemingly setting the stage for a new chapter in Evans's case. The battle, however, was far from over. The state of Alabama was not willing to let the appellate court's decision stand unchallenged. In 1982, the Supreme Court of the United States granted Alabama's petition for a writ of certiorari, taking up the case for review. In a consequential ruling, the Supreme Court reversed the judgment of the Court of Appeals, sending the case back to them for further deliberation on the constitutionality of Evans's sentence. Notably, this Supreme Court decision was not unanimous. Two justices, William J. Brennan and Thurgood Marshall, entered an opinion concurring in part and dissenting in part. While they agreed with Alabama's legal argument regarding the specific issue in question, they also firmly held that capital punishment itself was a violation of the 8th and 14th Amendments of the U.S. Constitution. For these justices, the case was not simply about procedural errors. It was about the broader ethical and constitutional implications of the death penalty itself. Even as these legal battles raged on, Evans made a decision that left even his closest observers stunned. In July of that year, in a move that defied conventional logic and legal strategy, Evans fired his lawyers. He then took an even more drastic step, filing a motion to dismiss all further appeals. Many speculated about his motives. Was this an act of defiance, a final stand against a system he no longer trusted? Or was it a resignation, an acceptance of a fate he believed was inevitable? Whatever the reason, it was an extraordinary moment that deeply revealed his personal struggles. In October 1982, the Court of Appeals accepted Evans's motion, formally closing the door on any remaining legal challenges. The Alabama Supreme Court was presented with a last-ditch application for a new sentencing hearing, but on February 18, 1983, they rejected it outright. At this point, there were no remaining legal avenues to explore. No more appeals, no more reversals. Here is how his final 24 hours went. 7 o'clock in the morning, Evans wakes up in his cell at Holman Correctional Facility, knowing this is his final day. The weight of his crimes, over 30 armed robberies, 9 kidnappings, and 2 extortion schemes, hangs heavy in the air. His mind drifts to that fateful day on January 5, 1977, when he and Wayne Ritter murdered Edward Nassar in a mobile pawn shop, with the victim's 2 young daughters as witnesses. As April 22, 1983 approached, Evans entered a liminal space between life and death. The Holman Correctional Facility, with its infamous electric chair, Yellow Mama, waited. Constructed by an inmate in 1927, the chair had a history as complex and brutal as the criminals it had dispatched. April 22, 1983. The date was etched in legal and criminal history, the day John Louis Evans would become the first executed inmate in Alabama since the reinstatement of capital punishment. The execution would take place at Holman Correctional Facility near Atmore, Alabama. The method, electrocution in the Yellow Mama chair, painted a distinctive traffic yellow, waiting silently for decades. At 8:30 in the evening, the first jolt of electricity surged through Evans's body. 1900 volts, enough to power multiple homes, instead channeled through human flesh. Sparks erupted from the electrode tied to his left leg. His body strained against the restraints, muscles convulsing in an impossible shuttle between life and death. Witnesses described an event of horrific technological failure, with a scene that would be forever hard to forget. 2 doctors filed out of the witness room, their faces ashen and professional demeanor barely concealing their horror. The prison doctor, dressed in a blue surgical costume and tan loafers with tassels, moved with clinical precision. He placed the stethoscope against Evans's smock, turned and nodded, a gesture that typically signaled the completion of a grim task. But this nod meant something else entirely. He had found a heartbeat. The electrode was refastened to his left leg. At the same time, a second 30-second jolt of electricity was administered. The stench of burning flesh became nauseating, overwhelming the senses of those present. More smoke emanated from his leg and head, creating a nightmarish visual of human suffering. Evans's attorney, Russell F. Kanan, who was present during the execution, immediately sought intervention. He asked the prison commissioner, who was on an open telephone line with Governor George Wallace, to grant clemency on the grounds that Evans was being subjected to cruel and unusual punishment. The request was summarily denied. A third charge of electricity, again 30 seconds in duration, passed through Evans's body. The witnesses, already traumatized, could only watch in silent horror as Evans was subjected to repeated electrical assaults. Finally, at 8:40 p.m., after 24 agonizing minutes, the doctors pronounced John Lewis Evans dead. The execution had become more than a legal procedure. It was a grotesque spectacle that would raise profound questions about the very nature of capital punishment. 2 Supreme Court justices had already argued that capital punishment itself was cruel and unusual punishment, prohibited by the Constitution. Evans's execution seemed to validate their concerns in the most visceral way possible. A few days before his execution, Evans had attempted to find a form of redemption. The after-school special Dead Wrong featured him sharing his life story as a cautionary tale. A killer pleading with young people not to follow his path, a final attempt at meaning in a life defined by violence. Evans's accomplice, Wayne Ritter, was electrocuted on August 28, 1987. What drives a human being to such acts of violence? What combination of circumstance, choice, and inner darkness leads someone to commit unthinkable crimes? John Lewis Evans's story offers no easy answers. Was he a product of his environment, a man beyond redemption, or something more complex? A human being whose capacity for both destruction and potential redemption remained forever unknowable? His final moments, those 24 minutes of electrical charges, smoke, and burning flesh, became more than just an execution. They became a mirror reflecting society's most difficult questions about justice, punishment, and the very nature of human morality. What do you think? Was justice served, or was this something else entirely? Leave your thoughts in the comments below.